All right. So we've got a great cross-examination to talk about today. Some great people to talk to you about the cross-examination. As always, we'll start with Roland just explaining, in case we have anyone new or in case anyone forgets, how we're going to work this, because it is a little complicated with so many people and doing it on Zoom. So Roland, please explain.
Hello, everybody. So first things first, you're going to use the raise hands feature if you want to speak. And so if you're new here and you don't know where that is on your Zoom, find that. It's down in the controls at the bottom. You can push raise hands. So just to make sure that everyone knows where it is, go ahead and push the button and raise hands, and I can see all your hands going up. There we go. I see hands going up all over the room. So good, you all found it. Now with a push, I can lower your hands. And the second thing is that we don't use the chat. So don't put anything in the chat. We're not going to follow that. Instead, we're going to do it all via raise hands. And once you raise your hands and we're going to bring you onto the screen, it takes a minute for Zoom to connect. It looks like you're disconnecting and then it brings you back on. So just be patient when that's happening. And also, if you raise your hand to come in, you may have to unmute yourself. You may have to turn your camera on if it comes up and both of those things are off. Okay, and remember, if you raise your hand, we're bringing you on. So don't be somewhere where we can't bring you on. Okay, that's it. Thank you.
All right, so let's just take a couple of minutes to set this up, and then we're going to bring the first. We have Gary Cohen, who many of you know. He's known around the country. He's a great trial lawyer, and I've heard some legendary stories of legendary cross-examinations he's done. I haven't actually been in the courtroom with him and seen it for myself, but I've heard stories. We're going to get his comments and bring him on in a minute, but before we do, let's just set this up. I'm going to try something a little bit new, which is we got the audio book, and we're going to, instead of me reading and probably reading too quickly, we're going to play a few clips for you. So Roland, let's play clip 1, which is just to set up what kind of witness this is, how hard, because it's easy to forget that this was a tough cross for Sandy Stern. Roland, we got clip 1. I can read.
But he has an undeniable presence. His native arrogance is translated by the witness chair into a developed confidence, becoming an expert physician. His qualifications are impressive. He has studied on 3 continents. He has given papers all over the world. He has testified as a forensic pathologist in homicide cases throughout the United States.
So this is a tough witness, well-known. He's got a lot of practice, and he comes across well on the stand. And so before we get into the cross, just a quick summary of the facts that come out on direct that are devastating for the defense. So let's play clip 2. Roland, please.
Painless used these facts and his own examination of the body to provide a comprehensive account. On the night of April 1st, Ms. Polhemus had sexual relations, almost certainly consensual in nature. This opinion was based on the presence of a 2% concentration of the chemical nonoxynol 9 and various jelly bases indicating the use of a diaphragm. The man with whom Ms. Polhemus had intercourse was, as I am, a type A secretor. Soon after she had had sex, Ms. Polhemus was bludgeoned from behind. Her attacker was right-handed, as I am. This can be determined from the angle of the blow to the right side of her head. His height cannot be approximated without knowing her posture at the time of the attack or the length of the murder weapon. The best indication from the cranial wound is that she had reached her feet, if only briefly, when she was struck. The diaphragm was apparently removed at this time, and Ms. Polhemus, already dead, was bound. Without Stern's objection, Painless testified that the presence of the spermicidal compound, coupled with the unlocking of the doors and windows, led him to believe that a rape had been simulated in order to conceal the murderer's identity, and that the murderer was someone familiar with the methods of detection of crime and Ms. Polhemus's routine responsibilities in the PA's office.
So I want you to, obviously the narrator is the defendant, and so there's the type A blood match. But really, a more important point that's brought out on direct is that the prosecution contends that the murderer had knowledge of criminal investigative procedure, and the defendant is a prosecutor. So this direct went very, very, very well for the prosecution. So before we get into the details of how Sandy Stern handles that in terms of the structure of setting a trap and the style that he uses to set the trap and the effect, let's just talk about how Sandy Stern and his trial partner, I forget the name, handles this damaging direct examination. So let's play clip 3, and then we'll get Gary, and then we'll get everyone else's thoughts, or as many as we can, on this.
Both Stern and Kemp on either side of me watched Painless do his stuff with a calm approaching the beatific. Neither one bothered to take notes.
So not just calm, and we'll bring Gary on now. And if you've got a comment on this, we're going to be talking about nonverbal communication. Remember to raise your hand, and then it takes a minute, but I bring you up so we can hear from you. So Gary, you're muted and your video's off, so hopefully you can switch those on. But what I want to ask about is they're not just calm as this damaging information is coming on. They're actually not even taking notes. So what are they up to, Gary?
Well, they have, they know their hand. They know what they have, and they know that the witness is unknowingly to him hanging himself by talking about the spermicide, which we later find out was either from another person that was unintentionally sent to the lab, or intentionally done in cooperation with the prosecutors. So they're sitting there appropriately, not showing, by making like rolling their eyes or saying, oh, have that face on that says, oh, good, we got him. They're just sitting there, as they say, beatific, because they know what they got, but they can't show it.
Yeah, so it's a good point. I actually had missed. I'm smiling because this question didn't go exactly how I was envisioning. In my mind, I was thinking of a direct that is actually devastating, because as the reader, when I was reading the direct, it appeared devastating. But you're right, they knew something that I, as the reader, didn't know, and so they weren't worried about it. But so let's pull it out of the book for a minute and just talk about when damaging information does come out. How do you handle that in terms of what just your demeanor, your actions, what you're doing in the courtroom, and why?
Well, in any trial you are in, you're going to have damaging expert or damaging evidence coming against you. That's just the nature of trials. And so you can't roll your eyes. You can't act like you're shocked. You definitely can't make faces. And one of the worst things I've seen trial lawyers do on both sides is to react, either by giving a sort of titter or looking at their partner and saying, like what's he talking about? Or laughing at times, sort of like not out loud, but a big smile and a giggle and writing something down. It's the last thing you want to do non-verbally. The jury is looking at you at all times. And I've been in cases where, when I was younger, my fault, and I've been in many cases where I've seen defense lawyers, some very good ones, do exactly that, and you see the jury react to it. If you're watching the jury and you're looking at that lawyer in front of the jury, and he makes a certain motion at the table, or he gives a guffaw, or rolls his eyes, jury hates it. Jury doesn't know what evidence is true and what isn't at this point. They want to hear both sides, and just because you know it's ridiculous or not true, jury doesn't know that.
Yeah, so I think most of the people here know, I've mentioned it a lot of times on this book club and in other things that I've taught, that when I was a juror, it had a massive impact on me and how I thought about trying cases. It really did. Whenever there was a reaction of one of the lawyers, the first thing it did was I woke up. You know, I might have been paying attention, but suddenly I they might have been laughing, the prosecution laughing at the defense evidence, but it made me remember it and think of it. So that's the first point. And then secondly, yeah, I didn't trust they hadn't earned my trust. So I wasn't looking to them for how to interpret the evidence. I think that's right. I think this is largely an uncontroversial opinion, but I would love to have someone disagree with it or add to it if anyone has any points about, how to deal with damaging testimony, what you do, whether you take notes, whether you ignore it, whether you react in some way. As I say, I don't think it's that controversial, but I think it's an important point to bring out when you're trying cases. Please remember. All right, we have one person, Herb Cohen. We'll bring him on. Maybe it's not. Maybe it is a little controversial. How else would you handle that, Herb? So Herb, your video and you're muted. Let me switch to another subject and get this started, and then we'll leave you up there so that you can.
Yeah, I think I got it now.
Okay, all right, go ahead.
Okay. I started to say, John, that you invited me because you said I'd like to hear someone disagree. So
Yeah.
Here's what I'm going to say briefly. Normally, I'm of the position in school that when I get ready and geared up to finally get to the point where we're going to trial, when I get up in the morning, my mindset is I'm putting on my uniform, I'm putting on my war paint, whatever the look is that you want. As far as making gestures or reacting, you sure don't want to do it as a lawyer without control. So I will disagree with you per your invitation slightly in the sense that I've done it before and reacted after years of learning that when I want to, when someone of the opposition says something and I want to kind of respond to it and I can't do it verbally, you can intentionally make a face, move a shoulder, do something that would get their attention to show that you're objecting without objecting.
Yeah. So look, yeah, I guess, look, there are some things you can do just especially if you're very experienced and you're knowledgeable about how you come across. Just as a warning though, many of us don't really know how we come across. And I think that's especially true of lawyers. They don't know how other people perceive them. So you have to be very careful with that. And just don't forget the power in what Gary was originally saying, which is if you're sitting there in this case, it was true, but even if it's not true, if you're sitting there calmly, not even taking notes, it's a powerful communication to the jury that I already know this. I already heard it. It does, and I'm still supposed to win. It doesn't hurt my case. And you can do that without offending anyone just by staying calm and minimizing your amount of notes. But all right, I'll leave both you guys up there. And then let me just before we get into the meat of this, which is the structure and the drama of the cross-examination, we've now talked about the direct and how it was good, how it was a tough witness and how they handled the direct, how the defense lawyers handled the direct. Let me just talk about the fundamentals of the practical fundamentals involving nonverbal communication with your cross-examination. So, Gary, tell us a little about where you stand and who you're looking at when you're giving a cross-examination.
Well, you're approaching the witness as close as you can get, first of all. It's my belief. Some courts will allow it, some courts will not. And you slowly, as this lawyer did, Stern, lay your groundwork. You can't just rush right into the aha moment. You have to lay your groundwork carefully. He did it. You have to speak to the jury, though. You have to look at the jury at various times because you're really talking to them. And even though you can't stand in the box and stare at the jury the whole time, you want to have contact with the witness, especially in this case, you have to see how the jury's reacting. So I move around a bit. So I'm going from the witness back a little bit to the jury, and I'm trying to make my points as I'm slowly setting up the trap. I'm slowly laying out, okay, so we can agree on this, and this is fundamental to your opinion, doctor. And without this, your opinion is invalid. Yes, yes, yes. And, you know, bring out his arrogance a little bit. You want to play on that a lot. And then when you have the trap set, let him fall and then just wait. Have his mouth drop. And you just stand there and look at the jury and look how they're looking at him.
Yeah, so I want to expand a little bit that on looking at the jury. So if you've never done this, where you ask 3, 4, 5 or longer string of questions, 10, 20, 30, without looking at the witness, looking at the jury, because you're communicating them, you know, you're questioning the witness, but they can feel more like declarative statements. So the way Stern begins the cross-examination, in my mind, I pictured it as him looking at the jury, talking to the jury, and ignoring the doctor. I reread it and it's not in there. So I was just making an assumption based on other people I've tried cases with who do that, especially Bob, my partner, who does it maybe too much. But just think of it like that for a second. I'm not gonna get the words exactly right, but if Stern comes out, stands up, and instead of saying, "Good morning, doctor," and has this you're the jury. In this conversation with the witness, if Stern is looking this way, if you're looking this way, the jurors are going to look that way. You know, their focus is on the witness. If instead Stern gets up, comes to the podium, and says, "Dr. Kumagai, you have testified before." That's a statement, really, telling the jury, this guy has testified. You have testified hundreds of times, have you not? Then what does he get into? You've told us about your papers and your degrees. But doctor, has your competency ever been called into question? That now there's a communication you're having with the jury. It's different than if that communication is with the expert. So I suggest you try it, and I'd like to get other people's thoughts on that. Let's go ahead and bring Rich Newsup on up to see what he thinks, and then Gary and, well, he's coming up. Gary and Herb, you got any thoughts on that?
I agree with what you said. It's when you can present the question to the doctor, but you don't do it the entire time. You also look over at the jury and give it right to them. You know, let him build his arrogance up, let him build himself up, because he's about to take a big fall. And you want to be looking at the jury when that happens, so they know that you're talking to them, and you're building a relationship between you and the jury.
I have to give compliment Rich, because I just noticed he's already drinking. I was thinking maybe we should make the drinks at the beginning of this and have a better discussion, but Rich, what do you think?
Yeah, no disrespect to you guys, but this is one where I disagree. I
Good.
think this is for me, but I want to ask everybody here, how many times have you ever had a real conversation with someone in real life where you're talking to one person and looking over here? It is unnatural. I think it's artifice. It's fake. And to me, I just don't buy it. There was a conversation we had on one of the other trial school presentations, I think last Friday, the Friday before. And I know that this differs from lawyer to lawyer, but for me, it doesn't work. I think it feels insincere. It feels like a trick. And to me, the number one thing is I want to be as real as I can. And for me to be real, I'm going to have to talk to that witness. And two, I want to study that motherfucker. I want to look at what he's doing, what's his face doing, how's he reacting. And, you know, not to jump ahead, but Stern did this, you know, he was having to bring the guy back just to nail him down on some basic stuff, and not being a jerk about that, but I still think that it is mano a mano. I'm all for moving the podium right smack in front of the jury and, you know, looking over at them from time to time. But for me, it's got to be natural. And this whole talking to the jury thing just feels like a big fake show to me, and I wouldn't do it.
So just to be clear, I'm the proponent of the fake show. I don't think Gary was actually saying that. I think Gary is a lot closer to what you were saying, Rich. And Herb, I'm sorry, but let me just let Gary respond because where do you stand on that? I don't think you're actually all the way over with me. And then
That's why I said I move as close to the witness as I can, because I want to engage the witness and sometimes intimidate, engage the witness. But I walk back and forth. I don't just stand there and look at the witness unless I really, pummeling him on something. I stand there and I walk back and forth between the podium and the witness, and I look at the jury at various times. I don't believe in standing in front and doing your entire cross in front of a jury. That's ineffective, in my opinion. You got to see the witness. You got to look the witness in the eyes, but you also have to see how the jury is reacting, because sometimes you get the feeling they don't like what you're doing, and you got to know that. Or they don't like how you're treating this witness, and you got to know that. So it's a combination. It's no simple matter of just doing it this way or doing it that way. Different witnesses you treat in different ways. Different juries you treat in different ways. But my focus is to bring the podium as close, walk back and forth, and I pace a bit. I know you can't do that in federal court, but in state court, you pace back and forth, and so you can see everybody and have everybody join in, basically. It's not just you and the witness. It's how I've done it and how I believe in it.
So look, there's an agreement between two of the best trial attorneys in the country who disagree with me. So go ahead, Herb, what did you want to say?
Thank you. It's not that I agree with Gary because he's a Cohen. I do agree more with Gary for this reason. Well, it's a combination. It's a complex scenario. We as trial lawyers hopefully prepare for that witness is coming up. So we know where we want to go, and having read their deposition and statements, we hopefully know what they're going to say. But I firmly believe you don't put a show on and just look at the jurors, but you got to learn to be natural, but you got to tie them in. We're there for them. I'm there for them. I want to win them over. So I want to tie them in and keep them as a part of the conversation. So if I say something, if I create a point, as Gary said, I'm with Gary. As Gary said, you build up to it. If then when you're ready to your build, when you create that point and you look over to the jury, you're including them. You're making them a part of, and you'll get the feel of whether they like what you're doing or not. And if they do, you keep going. And if not, you kind of switch gears. So you got to tie them up in.
I agree.
All right. So I do not want to spend too much on this preliminary issue, but I do want to take 30 seconds to say why I disagree. And just to say for a minute, I'm not saying that you're never looking at all at the witness. You're not seeing any weaknesses at the witness. And the biggest thing I want to disagree with is I don't think it has to be a show. In other words, I don't think it has to be a fake thing. If it is for you, then you better not do it, right? Any inauthenticity that comes into the courtroom, I think, is deadly. That's why we always never ask for a number that we don't believe. I think you're making a big mistake because the jury will sense it and you might even lose outright. It's the same thing here. If it's a show, if it's fake, then don't do it. But I think that a lot of people don't ever look at the jury. Way more people never look at the jury than look at the jury too much. I don't think looking at the jury too much is a big problem. I think that we should be looking at the jury more. And I think you can get a rhythm where you actually do make the witness kind of irrelevant. Even the answers sometimes. The jury's more focused on curious about what your next statement is going to be, almost as if you're telling a little story and the witness is trying to break in, but no one's paying attention to it. It can happen. So anyway, but that's why it's great to have the great people here. Anyone want to end with it so I don't get the last word? Okay. All right. I'm going to take the last word. All right. So it's a perfect transition because what Rich said, what both Gary and Herb talked about was paying attention what the witness is doing so you can take advantage of opportunities. So the next thing I want to talk about is being alive in the courtroom. It's the last thing we'll talk about before we really get into the laying the trap, the structure of the trap, and then the style of how the trap is sprung. And then we're going to finish with talking about because every time I read this, I'm like, holy shit, he destroyed their case. He didn't. Okay, it just felt like that. And so that's why this is such a powerful teaching moment. You cannot establish that much. He did establish something, but it didn't eviscerate the prosecution case. It just felt like that to the reader, to the judge, to the jury, and even to the prosecutors. So if you can do that, it's irrespective of the strength of your case. But before we get into that, being alive in the courtroom. So let's play, we've got 2 clips on that. Roland, I think the first one is called clip 5 or 5A.
Just a second, says the judge. Just 1 second. The record will reflect that prosecuting attorney Molto has just made a gesture which I recognize to be a signal to the witness in connection with his last answer. There will be further proceedings with regard to Mr. Molto at a later time. Proceed, Mr. Stern. Tommy is crimson as he struggles to his feet. Your Honor, I'm terribly sorry. I don't know what you're talking about. Neither do I. I was watching Molto, but Laren is inflamed.
Laren's the
This
judge.
jury is not blind, Mr. Molto, and neither am I. Proceed, he says to Stern, but his anger is too great to store away, and he immediately wheels his chair around in Molto's direction and gestures with the gavel. I warned you. I told you before. I am very upset with your conduct during this trial, Mr. Molto. There will be proceedings. Judge, says Tommy despairingly. Resume your seat, sir. Mr. Stern, proceed. Stern comes over to the table. I explain what I saw. He, too, observed nothing. But Stern does not let the incident pass. In a mincing tone, he asks, it is fair to say, Dr. Kumagai, that you and Mr. Molto have always had good communication. Is it not? The question evokes a few snickers.
So it didn't mean anything, but he was just paying attention, and he jumps in with, I mean, there could be no note about that. You guys have always had good communication because the judge was accusing them of having it. I'll play one more, just a short one, 7A, which another thing of him paying attention in the courtroom. And then anyone who's got a good story, either who's up now or anyone else, about them when they were paying attention in the courtroom, or another lawyer who did something to a witness, I want to hear it. 7B.
And to explain those phenomena, particularly the dead spermatozoa, you theorized that the attacker was sterile. It did not occur to you at first, Doctor, that a spermicide had been used, did it? Apparently not. As you look back, you must think you were a fool to have missed something so obvious as the use of a contraceptive spermicide. Make mistakes, allows Painless with a flip of his hand. You do? Asks Stern. He eyes the state's expert. How often? Kumagai does not answer that. He recognizes his miscue.
Wow, isn't that a great question? Asked so calmly. How often? I mean, it's impossible to answer. So, but you got to be paying attention. You can't be tied to your notes. So any of you guys got a good story about that? Or you want to comment on it or disagree?
Which part?
Well, about being, what I call being alive in the courtroom, right? You know, we're so tied to what we want to get from the witness. Sometimes we miss the opportunity, like you guys were both saying, paying attention to the witness, sensing a weakness, and taking advantage of it.
Yeah, I don't do much note taking. I try to keep the facts in my head, and I try to read the witness and listen to what the witness is saying and be able to react to something based on that witness's personality. In other words, if you have an arrogant guy like this, who's tried to come across as the world's expert on so-and-so, it's okay to say, oh, you've made mistakes? How many times have you made mistakes? Can you list them for us? Have you been, in fact, shown that you've made mistakes by other prosecutors? And that's why they call you painless, because the only people who don't feel your pain are the dead. It's okay to have that with a guy like this who's arrogant. Now, with a different witness, you can't get away with that.
Yeah, well, right. So being alive to the courtroom is not just sensing the mistake of the witness, but also watching the jury and how they respond. We've got Alan's got raising his hand, so maybe he's got a story about this too. We'll bring him on, and then we'll move into the structure. So Alan, your videos, and there we go.
There you go. Hi, how you doing?
Good.
My story, it goes a little different. You have to pay attention all through the trial. I mean, I just remembered something when you were talking. I do mostly DUI defense work, as Herb knows. And one time I'm picking a jury, and the state attorney's up there, and he asked one of the witnesses, who here doesn't drive, and who would just throw their license away? That was the whole thing in a refusal case. And he goes to a woman and he goes, "Ma'am, you look like you don't drive. Why don't you drive?" And she looks at him and she gives a look like she's really upset. And she doesn't want to answer. She goes, "Well, tell me, man, why?" "I'm epileptic," she says. And I was like, oh my God. And I was lucky I was paying attention. So I whispered to my client, "When it's my turn to get up, I want you to grab my shoulder and whisper so low that nobody can hear in my ear. Just do what I ask you to do." And he does that. It's my turn to pick a jury. I get up and my client grabs my shoulder, whispers in my ear, and I get up and I go, "Ladies and gentlemen," and I had already noticed that the whole jury was appalled that, the answer the lady gave, and they were upset. I go, "Ladies and gentlemen, I'm sorry. My client has just asked me to make sure I do not ask any questions of any of you that would affect you in any way or hurt your feelings in any way. So I apologize for this misconception." And I start up again. But I caught that they hated what happened, what the state attorney said, and I wanted to make us look good. So I had him whisper in my ear, and then I let him make him look good, saying, "Let's protect the jury." And it just reminded me of that when we're doing that. It's not with the witness, but I think it's at all times you have to pay attention to what's going on and not stick to your story at all times. Sometimes you have to go off when you see something that's important.
Yeah. So, and it becomes easier with experience, but those are, that's what you have to do if you want. We come in with our script, and it's not going to play out that way. So we've got to pay attention. I'll tell you a quick 30-second story about another lawyer that I saw this happen. It was my second trial, and so it was a product liability trial involving I think it was a rollover case, and so. It was my partner, Bob, my boss at the time, and he said, "Give me the notes for the cross." So I stayed up all night, and the next morning I gave him like 30 notes, and he's like, "What's this? I can't use this. 1 page." This was like 20 years ago. I'm like, 1 page? So finally I get it down to 1 page. He looks at it. He's like, "Good." And then he doesn't take it up with him when it's time for the cross. And it was the automotive defense expert, Lee Carr. I'm sure you know him, Rich.
Wow.
So he gets up there and he says,
and by the way, this, for everybody, like, Lee Carr is maybe one of the best professional expert witnesses of all time. He would come in looking good. I mean, all right, so I got to hear the story. So what happened?
Yeah, and Bob knew that. I mean, I would say that we were scared of him, right? We knew that he could hurt us. And so it wasn't from like lack of caring, okay, that he did this. So he looks at it, and one of the things on there was that he charged $1,000 an hour. And this was 25 years ago. So, look, it's not that deadly, but the defense hadn't brought it out. So the first thing he does is he gets up and he says, was he a doctor, Rich? Dr. Carr, Lee Carr?
I think it's a PhD, yeah.
PhD. Well, so he might have said doctor, I don't know, but he said, so you charge $1,000 an hour. And Lee Carr says yes. And so Bob said, "Is that what engineers get paid these days?" And he said, "It's what I get paid." Didn't really hurt him. So Bob's just now trying to think of another, he doesn't have my notes up there, my 1 page. He's just trying to think of another thing on there. And about 5, 6, 7 seconds go by. It gets a little uncomfortable. He's just planning. He thinks it's over. But the silence, I guess, got uncomfortable for Carr because he just blurts out, "And I resent the implication that I'm being paid to lie." But it was over. The fucking trial was over. I mean, Bob just spent about 15 minutes, and every question started with something about being paid to lie. There, no one remembered anything about that and no one was thinking that except him. He really was thinking that because he did get paid to lie. That's why they paid him so much. It was the truth. He just blurted it out, and then he didn't. The rest of my notes, he didn't even. He got in no technical. Just every question with something to do with that. So you got to pay attention. All right.
Next.
So go ahead.
Go ahead, Herb.
Can I tell a quick story that I thought of while you were talking?
Sure.
Thank you. So there was a time that I was on the courthouse list for first-degree murder cases, and I remember being in trial, and it all fits in with what you great guys are talking about paying attention. So this really tickled me. I hadn't thought of it for a while, and I was defending a guy who was charged with kidnapping, and he was a member of this gang here in South Florida called the Sharks, and they had tattooed sharks on their bodies, and these nice young men. And the victim gets on the stand before lunch and he's testifying that, or someone else testified that when he went into the Sharks clubhouse, after he stole stuff from them, he peed on the floor. So the other co-defendant lawyers do some cross-examination. They take a lunch break and the victim comes back, and he left the courthouse for lunch and comes back, and it's my turn to cross-examine him. And I started off with that because I just thought it was something that the jurors are going to think about. So you went into the clubhouse, you stole their stuff, you broke in, they were mad, so they're charged with kidnapping you and beating you up in retribution, but you peed on the floor. I said, let me ask you a question. You went to lunch today, is that correct? Yeah. You went outside the courthouse, did you have a good lunch? Yeah. When you came back, before you entered the courthouse, did you pee on the courthouse? Did you pee on the courthouse lawn? I don't know why I thought to say it. It's a true story. I asked that question. I got an acquittal. It made this guy look so bad, the jurors just they thought he, God knows what he did.
Trials turn on little moments. That's why you got to be so awake.
Yeah, and
Right.
I'm going to tell a 15,
sorry,
20-second story about the best trial lawyer I've ever seen, which John and I both worked for, Sheldon Schlesinger, Lord Sheldon Schlesinger. And a number of years ago, he was in a courtroom on a train accident that ran over this guy's and cut off his legs. And the last minute, the train company, which we all know, East Coast Railroads, found this witness, this basically a bum on the street found, and they brought him in, listed him as a witness to testify that he had spoken to our client before this happened, and he said he was going to try to kill himself by throwing himself in front of a train. Shelley didn't take his deposition. They put him up on the stand. They went through all this, and the guy basically, killed us because it was going to be, oh my God, this guy had talked to our client, and he said he was doing this on purpose. And Shelley didn't use a piece of paper. He didn't play with any games. The guy was wearing sunglasses. And just on his intuition, and again, that's why you have to look at the witness. That's why you have to read the witness. And Shelley used to do this thing with playing with his glasses and on and off. And he, had a half glasses, and he'd say, "What do you do?" in his heavy Brooklyn accent. And the guy said, "Well, I'm unemployed right now." He said, No. "What do you do?" And the guy said, I told you I'm unemployed. "What do you do?" And the guy said, "What are you talking about?" The guy said, getting angry and angrier. What are you talking about? What do you mean what I do? I told you what I do. "What do you do? Uppers, downers, reds, blues, narcotics, this and that, just every car." And the guy says, "I don't do drugs." And he says, "Then take off your shades and show your eyes to the jury." And the guy said, "Fuck you." And he's no further questions. That was the entire cross, and that was a $5 million verdict. Because he read the situation. He read the witness. It didn't matter what he had to say. He was gone, and so was Florida East Coast Railroad.
So stories like that, I think that it's helpful to all of us to hear stories like that because it widens the box of tools, that you have of what you can do. I would also suggest that, number one, we can all be better trial lawyers just by walking into the courtroom and thinking that I am going to pay attention. I'm going to look at the witness. I'm going to look at the jury. I'm going to find my moments and make them. Just making that decision and doing it, putting right at the top of your note, every piece of paper you have. And then secondly, hearing about moments, reading books like this, you guys know I believe in that. But third, I would say, just for me, I know I would bet $1 million that Shelley didn't meditate, but meditation for me has been a really, really useful thing for me to pause in moment after moment in dramatic moments and see what's really going on. So I encourage people to do that. I'm going to send out a poll if we want to do a book on Buddhism or, meditation. But
I would say right, count me in. I mean, I feel the same way. I've just started that recently, and there's enough really brilliant trial lawyers that are all saying the same thing about meditation. So sign me up, John. I think it's great.
John, there's an interesting book out called Breathe. It just came out within the last year, and they talk about breathing and meditation and everything it will do. I found it very interesting. I just finished listening to the audio book last week, and it's fantastic about meditation and how you breathe. And a lot of people breathe through the mouth as opposed to the nose, left side breathing, right side. People may be interested in that. It's really about calming down and relaxing and getting into yourself and things of that nature. I recommend it since we're
great. Yeah, I'll pick it up. I'll read it. Thank you. All right. And so I'm going to play another clip. A reminder to everyone, if you have a point you want to make, raise your hand. We want to hear from everybody if we can. Obviously sometimes we just can't there's too many hands raised, but if you have something to say, raise your hand. I really want to try and get in as many people as we can. All right. So we're going to turn to the structure of the trap Sandy laid. So let's play 6, which is where I think he's laying the trap. This is about 1.5 minutes.
Now, that report, sir, concerned the semen specimen which you had taken from Ms. Polhemus during the autopsy. Is that right? Right. And it is that specimen which has been identified as being of Mr. Savich's blood type and as containing chemicals consistent with the use by Ms. Polhemus of a birth control device, a diaphragm. Am I correct? You are correct. And the presence in that specimen of this birth control chemical, the spermicide, is critical to your opinion. Is it not? All the facts important, Mr. Stern. But that fact is particularly important because you, sir, want us to believe that this tragic incident merely had the appearance of a rape. Do you not? Don't want you to believe nothing. I give you my opinion. But it is your opinion, to get down to brass tacks, as they say, that Mr. Savich tried to make this look like a rape, correct? If you say so. Well, is that not what you are trying to suggest? You and Mr. Molto and Mr. De La Guardia? Let us be plain with these people. Sandy points to the jury. Your opinion is that this was a staged rape, and that the way it was done suggests some knowledge of investigative techniques and of Ms. Polhemus's regular duties in the PA's office, correct? But that's what I say on direct. And all of that points at Mr. Savich, does it not? If you say so, Painless says eventually with a smile. You can see his reluctance to believe that Stern is inept enough to implicate his own client. But Sandy keeps forcing the issue, saying more than Kumagai would risk on his own, and Painless takes his characteristic pleasure in someone else's misfortune. And all of those deductions depend in the end on the presence of spermicidal jelly in the specimen you sent to the forensic chemist, do they not? More or less. Much more than less, is it not? I would say, so this specimen and the presence of the spermicide is critical to your expert opinion, says Stern, arriving at the point where he was a moment ago. This time, Painless concedes. He shrugs his shoulders and says, "All right."
So let me just summarize that for a second. He has now set the trap. If the sample is discredited, the witness is discredited. He's already established that, but he doesn't spring the trap yet. Okay, so I want to play one more clip about what he does first. He sets the hook much deeper. That's why he devastates the witness. I would almost always spring the trap now. I got him logically, but trials aren't just about logic. So Sandy Stern does two things that I really learned from, right? I hadn't read this since, I don't know, law school before. Well, rereading it, I saw something in my own lawyering that I could improve. Don't spring the trap just because you've logically set it. Sandy Stern taught me two things. He set the trap deeper so that he destroyed the whole witness, not just part of the case. And then he did it in a way that was dramatic. He built the drama of the moment, and there are the tools we can learn from that. So I'm going to play the next clip and then get your guys' comments. But so we don't have two long clips in a row, why don't we bring in our bartender to teach us how to make a drink? It's only 4 minutes. Remember, we send out the ingredients, and we have volunteers who we actually send them the ingredients so they can make the drink in front of you for your pleasure. So let's bring on our bartender. I think that the bar in Manhattan is open now, where Mac is the mixologist. So maybe he's there instead of his apartment. There we go.
Hey, everybody.
Are you at work, Mac?
I am at work.
That's exciting. So bars are open in New York?
What's up? Bars are open. We have some renovations and things to get done and take care of for a little bit. And now we're back in action, and we're excited to be here. And I'm excited to be back again with the book club and teaching all of our lovely volunteers how to make a hurricane.
All right. And we've got some wonderful volunteers. So guys, turn your volume on, your microphones on, so we can hear you making them.
Yeah, please. So I'm pretty sure we got Scott, Jim, and Megan. I'm 100% positive you guys will all be able to make a fantastic and delicious hurricane. It's a really awesome, classic New Orleans cocktail that looks just as good as it tastes. So there's actually a couple different ways to make this cocktail, multiple variations. We're going to go through one real quick, and if we have a little bit extra time, I'll show you all how to make a really easy, simple version of it also. So is everybody ready? You all have your equipment. You guys are good. You have everything you need. We got the pineapple juice. You got your triple sec. We got rum. We have grenadine, orange wedges, probably a couple of maraschino cherries. If so, you're ready to rock. I know I see some repeat volunteers in here, so I don't really need to go over all of our basics, but this is our jigger. So we're going to be using to measure everything, putting it into our cocktail glass, and let's just get right on to it. So here we go. We're going to do 2 parts of pineapple juice. All right, so let's do 2 ounces of pineapple.
2 ounces pineapple.
2 ounces pineapple. Go right into your tin. And then we're gonna do 1 part triple sec, so 1 ounce. All right.
That was 1 ounce of what? I lost
1 ounce of triple sec.
1 ounce of triple sec.
1 ounce triple sec, and now we're going to be adding a little bit of grenadine. Now you can either add the grenadine to the bottom of your glass if you want to layer all of these juices on top of one another, or you can just add the grenadine just a splash or a 1/4 ounce right into the bottom of our tin. So I'm going to go, I've already measured out a 1/4 ounce the shot glass. I'm going to go ahead and drop it right into there. Now, we do a little passion fruit too.
There you go.
No, I would watch.
Okay, bud.
And then 2 ounces of rum as well. So 2 parts rum, 2 parts pineapple.
Just 2 ounces of rum?
Yeah, you can put as much rum as you want. All right.
Put
Jim, Megan, Scott, we good over
a
here? Everybody
ball on me.
I'm good.
in? We good? Thumbs up. We're ready to rock. The next thing we need is gonna be ice. All right. All right. Ice our glass. Jim, Scott, you guys good? You got ice in there? Everybody ready to shake? Raise your hand if you're ready to shake. All right, cool. So let's go ahead. We're just gonna give this like a real quick shake. Hard but quick shake. All right, that's that. And I have some crushed ice here, but you guys can use whatever ice it is that you want. Go ahead and get some ice into your glass. Now, I don't have a classic hurricane glass because they tend to frequently break over here at our bar. However, I do have a wine glass. So if you do have a wine glass, it looks really nice and beautiful in a wine glass filled with some crushed ice, or just, you know, some regular ice, whatever you got. I'm gonna go ahead and put my ice in my tin, excuse me, my glass. I'm gonna go ahead and strain this right into there.
Nice.
All right.
Thank you, Mom.
And then we'll just hit that with a little orange slice garnish. I can put a little bit of bitters on the top of mine just for show. And voila. There you go. Now, real quick, I think we have like maybe a minute. If you want to do the same thing and do this cocktail again, I believe all of you guys can, Jim, Megan, and Scott. What you can do is go ahead and take a bunch of ice or crushed ice, all right? Put it right at the bottom of your glass, and you can just build this cocktail. So you can just go ahead and do 2 ounces right into your cocktail glass. So this is great for people who don't have a shaker. I'm gonna put a little bit of lime juice in this one, like a ½ ounce.
It's good.
Again with our passion fruit, voila. So we'll do the same amount, about an ounce of triple sec, 2 ounces again of rum, a little dash of bitters for show. We'll put a little more ice in the top of that. And voila, for everybody that may not have a shaker or wants to make the same drink, it's super easy. You just build it right in your glass. All right, guys, you did a great job. As always, my trusty volunteers. Cheers, guys.
Cheers.
Cheers.
Yeah.
Thank you guys for volunteering. And Mac, your bar is called Wayland?
Bar is called The Wayland, and it's on the East Village on 700 East 9th and Avenue C of New York City.
All right.
My husband's name is Wayland.
Oh, really?
Oh, yeah, he'll get a shot. Tell him to come on by. Shots for anybody named Wayland.
That's
Well,
really
I
funny.
got orange.
You can get an
Yeah,
orange too.
there's my cocktail, my tester. Thank
All right.
you.
Thanks a lot, guys. Appreciate it. Have a great night.
Thanks, Mac. So I just found this Curious Elixirs. They're non-alcoholic drinks, but they're not like, I haven't tried them. We just bought a case. We bought a case of Negroni-ish, which I guess tastes like Negroni, and Cucumber Collins. So if you want to try one of those for next time, we'll ship it to you. Just email me and your address, and we'll ship you one of those. I only have a case of each, so not that everyone's going to want one, but there's a lot more people on the attending than we have. But let's try those for anyone who doesn't want to drink alcohol. All right, so guys, let's get back to this because I'm excited about it. So let me just play, before I ask anyone their thoughts, let's play clip 8. I just want to make sure I didn't get ahead of myself. Yeah, let's play clip 8 because he's logically, the hook is already set. He's got enough to spring the trap, but he doesn't. What does he do in clip 8? Roland, can you play that?
Let us consider some alternatives. For example, Dr. Kumagai, you would be convinced that birth control would not be used by a woman who knew she could not bear children, correct? Sure, he says, but Miss Polhemus got a child. So the evidence has shown, remarks Stern. But let us not consider the particulars of Ms. Polhemus. Just bear my example in mind. If a woman knew she could not conceive, it would be unreasonable for her to use a spermicide, would it not? Sure. Unreasonable. Painless agrees. But his answers are growing slower. His eyes seem thick. He has no idea where Stern is headed. Absurd? I'd say. Can you, as a forensic expert, conceive of any reason that such a woman might use a diaphragm or a spermicide? No reason. No medical reason. I think of nothing.
All right, so we've got Rich and Gary up. So let me ask you guys, what did he do there that's any different than he'd already done? Why does he do that? I mean, I have my opinion on it, but what do you guys think? I mean, is he just wasting time? What do you think of that clip we just played? Well, you're both on mute, sorry. Maybe I muted you. If I did, I apologize. But
Gary,
mute yourself.
go ahead, Gary.
Okay, I got it. I think he's just painting the doctor into a corner to the point where there's no way to get out. He's doubling down, but on what he knows is coming. And so what he's doing is very carefully, very deliberately painting that floor and even a little corner left. And that's where he's going to spring his trap.
So let me, Rich, before you say, let me just say something about that. So I should have mentioned it earlier. The trap is not set if there's a way of escape, right? So yeah, you've got to make. We can't always, and sometimes the witness doesn't get their way. They don't know the escape hatch you fear and know is there. But if possible, we cut off every avenue of escape for the witness. So that's part of laying the trap, and he's doing that. So thank you, Gary. It was malpractice Gary does a lot of medical malpractice. It was just bookshelf, top shelf malpractice that I didn't mention that. But Rich, what were you going to say?
No, I agree completely. I mean, I think there's different ways that he could have done it. He's kind of an old school lawyer. We have the advantage in civil cases, obviously, of having depositions. So we would probably also be able to paint him quite clearly with a big old depo clip, or best of all, a video clip that we'd put on a giant 10 by 12 screen to really underscore it. A lot of us use what I call an agree board, which is a giant flip chart that I'll actually use at the beginning of a cross like this, of the things that I need to nail the guy down. Sometimes it's just to show that there's common ground, that's not something we're fighting about. But a lot of times it will be something like this, and it can be as simple as a giant flip chart where you just write agree at the top, 1, 2, 3, 4, 5 in your own handwriting, and it's just another way of nailing someone down. So this lawyer, he's an old school kind of guy, and so he just did it the way he did it. There's different ways to do it, but yeah, you got to nail it down before you spring it.
So Rich, that's a really powerful tool to do what Gary was talking about, cutting off every escape hatch. And you have talked about that in more detail. That was very nice of you to say. A lot of lawyers do that, but as far as I know, you invented that. I didn't know anyone who did it, and now I think I got to do it in every case. Now that's legal malpractice. But so where did you talk about that? I think it was was it in the pretrial checklist? One of the trial school, they can look it up, but I can't remember which one it was. They agreed.
We've done it. I think when you and I were talking about PowerPoint, there was a PowerPoint, or we just did it last week. There's going to be, if you join us, if you remember trial school, and even if you're not, you can join us. This is open for everyone. The great Carl Douglas, who was on the O.J. Simpson Dream Team, one of the best, truly greatest trial lawyers in the country, with Mike Kelly, who's a member of the Inner Circle. And I was lucky enough to get on this panel with these guys. But we're doing a thing tomorrow on closing arguments, and I talk about the agree board. And the power of that is that at the end of it, you can take a picture on with these things, it is like supercharging demonstrative exhibits. You can literally take a picture of all the crap that you create on a chalkboard or a flip chart or whatever, take a picture of it and incorporate it right into your closing. So, or to use it with other witnesses. But yeah, the agree board is something you can see examples if you join us tomorrow.
Tomorrow at noon,
yeah.
Right?
Tomorrow at 1 o'clock Eastern.
1, sorry, yeah.
Yep.
Okay, so the agree board is great tool. Thank you, Rich. And Gary's point about cutting off escape hatches. I have one more thing that I want to add. I've read this I've read it like 20 times. Like, I want you guys to get something out of coming. So I'm sure I've read it. You know, you guys, Gary, Rich, and the people who are on have probably read it once, maybe twice. So there's one other thing I think I saw in there. But before we get to that, Scott has something that a point he'd like to make. So we'll bring him up and hear what he has to say. And then I'll tell you the points I got. And again, we're talking about structure right now. We're going to turn to the drama and the style of it in a second. Hey,
So,
Scott.
Thanks, John. I wanted to just ask a question and maybe make a point. You were saying in the cross, where Stern gets him initially, that you would then spring the trap sooner, but he wants to set the hook deeper. The thing that worries me about doing that is, you know, it's like asking one question too many on cross. You know, sometimes you go too far and they find an escape hatch that they didn't have before you got there when you could have sprung the trap. And so, you know, for the high drama of this book, that was great, but it made me, I remember as I'm reading it, I got a little anxious that he hadn't sprung the trap yet. And I just kind of wanted your and Rich's kind of take on that, and Gary's take on that.
That is a great point, Scott, that I didn't think of. Okay, Scott Turow is writing a book and he has control of what the witness says. Okay,
Yeah, right.
When we look at Bruce Henderson's and Bugliosi's book, which is the real actual transcript of the cross-examinations, there's potentially more value there. You're right, and I know we've all asked far too many questions in every trial, and sometimes it's hurt us. But here's what I would suggest to you. I still have learned from Turow in that moment, on that point, because for me, my problem when I ask too many questions is not cutting off escape hatches. I don't ask too many questions cutting off escape hatches. I don't ask too many questions creating the drama of the moment. My too many questions are in other areas. So what Sandy did, and let's pretend for a minute that he's a real person and it's a real cross. In a way, you know, even when we look at Bugliosi, the transcript in the Sea Will Tell, it was just one witness, you know, and even when we look at our own experience, we can put too much weight into one of our own cross-examinations than it deserves. So even if it's successful in real life, we have to look at it with a little suspicion, just like we do with a fictional book. I just have to say that, you know, presumed innocent doesn't hold up well in some ways. I mean, it was written a long time ago. It's very obvious. I almost hesitated assigning it, but he has insight into what's going on in the courtroom that is very rare, that I have never seen. So that's a way too long answer for me to say. Sandy is smart in what he does. There was very likely going to be a conviction in this case. At the end of this cross, without logically establishing innocence, he has everyone, even the prosecutors, feeling, and you know, that's a powerful, like, you know, when you feel like, sometimes we don't even stand up for ourselves when we feel our position is stupid, right? He has everyone feeling that it is a stupid position. And so if we can learn how to do that, he could not have done it if he didn't cut off all escape hatches. And then the extra questions, let me get to my point on this. The extra questions that I think he did in that moment were risky. He said absurd, right? But he had already cut off the escape hatches. And it wasn't, in that moment, Painless isn't talking about his own opinions. He's just saying it would be absurd for her to use contraception if she couldn't conceive. It would be absurd. But think of the genius of that for a minute. He has now, that word absurd has been introduced as, and it's been attached to his opinions if the sample is, the credibility of the sample is called into question. So instead of the credibility of the sample has been called into question, cut out that piece of evidence, look at all the other evidence showing towards guilt. He has made the witness absurd by taking a minute to use that word. and then no reason, no medical reason. I can think of nothing. Yeah, it was risky to push him to the point, but is there an answer? Is there an answer to that question? Probably not. So if you have if you have the ability to push someone to use a word like absurd and say, I can think of no reason, and then spring the trap. Not when I would have done it normally. Like I'm a logical thinker. I have the logic. I made my point. The jury's going to understand it. Let's spring the trap. No, he is introducing words like absurd. No, I can think of, he has the witness say, I can think of nothing.
Right.
So my answer is, yeah, we ask too many questions, but not when you're laying a cross trap.
Your point on that, and I think you're right. If you can go further with where you're going to introduce, like, deliberately and strategically words like absurd and so forth, but right in there, he asks that open-ended question, which is like walking on a typewire without a net. I mean, that really made me anxious when I read that.
But Scott, let me just talk about that. I know, Rich, you want to say something, but this is exactly, and I didn't put this together till you just said that, but Bugliosi talks about in And the Sea Will Tell, the open-ended question, and when he likes to ask it. This is when he likes to ask it. There's no good answer. So he asks an open-ended question. He's encouraging us to ask open-ended question in this exact situation. It's
Right.
a good illustration.
And it's good for the jury to hear that you're giving the chance, the chance to explain himself.
Yeah.
And he says, no, there's no other answer, because there is no other answer. And you can now have him committed to an absurd opinion in his own words.
Right.
Well, that was my whole point. It goes back to my first point. If you're watching the jury and talking to them, it's dance, man, between you and the expert. And maybe he used that extra word absurd because he felt in that moment that he was on a roll, and it is an art form. And so, Scott, to your point, I think that a cross-examination is about risk management. There's the safe questions where you've got a clean Q&A and a deposition where you can impeach. There's something where the guy's written something, or you've got a clean article that says those are the safe answers. Then there are these where there's a risk, but you've thought it through, and either the guy's going to look like an idiot or a liar if he disagrees with it. And I think you can take it and take your chance. And how far you go, I think, is the risk analysis that you've got to go as the artist, having a conversation with another human being, the witness, looking at his face, looking if he's fearful. Like if you look at what the book says, he says his eyes got thick. He was scared, man. He knew something was going on. And at that moment, when you got a guy, it's like after you've already popped somebody with an embarrassing impeachment, they will roll over and give you, I mean, I'm sure everybody's done this, but like when you've really mauled somebody in an embarrassing impeachment, you can get them to say stuff like, you ask them questions, sir, isn't this true? Well, I don't know about that. Oh, really? And you walk over and pick up an empty folder. And they're scared. Okay, yeah, I probably said that. And so it's all about risk management and the dance and your gut with whether the guy, is he going to give it up? And so I suggest that this guy is a seasoned warrior. He knew he could get away with the words like absurd because he had the guy with the thick eyes. He was on the ropes and he was going to give it up.
Risk management really makes sense. I think that's a good way to characterize it.
Yeah, and also think about it. He's not, when he says, he has no, sure, it would be unreasonable. Absurd? Who cares if he says no? It doesn't hurt. In fact, let me go back to when I was talking about talking to the jury instead of the witness. Okay, imagine in that moment that Sandy Stern doesn't say to the witness, it would be unreasonable for her to use spermicide, would it not? The witness, sure, unreasonable. Absurd? Imagine instead of that, he just goes, absurd to you, to the jury. Who gives a fuck what he says, right? You've eliminated yes, no, well, maybe she, who cares? You have now attached absurd to his position if indeed she could not conceive. So and I know we've got hands up now that want to get in on this, but let me bring it to the point. So now, so he set the trap deeper. He's made it to the point where, like, it's absurd if indeed she can't conceive. It's not just discredited, it's absurd. And he gives the open-ended question, and the witness says, I can't think of any reason. Now what does he do? Okay, and this is a learning moment, because not to go back get to way too much, like I always do, to my experience as a juror, but they don't know the important moments unless you tell them this is an important moment. So even with the drama of absurd, and that's another reason why I'd want you looking at the jury, absurd, so they know it's important. What does he do now? Let me just play clip 9, and then I will get to some of the other hands too. But pay attention to this. And why does I'm going to ask you guys why he does this?
No medical reason. I think of nothing. Sandy looks up at Laren. Your Honor, may the court reporter mark the last 5 questions and answers so that she can read them back later, if need be. Kumagai conducts a slow survey of the courtroom. He looks at the judge, the reporter, finally the prosecutor's table. He is actually frowning now. The trap, whatever it is, has been set. Everyone knows it. The reporter attaches a clip to the narrow sheaf of stenographic notes.
So let's bring Herb on as I ask you guys who are up here now. Who gives us? No one cares about the court reporter marking notes, and what is he doing there? Right. Let me read that to you again. Where he said, "The trap, whatever it is, has been set. Everyone knows it."
Right. Okay. To just go back quickly to just before that, what you all were talking about. When you talk about, or when I consider the depth or the breadth of cross-examination, and I think Gary and Rich both explained it in their way, I think it's a matter of whether you get the witness to agree with you, good thing, but what they were doing in that example, Stern was doing, is get the witness to make a commitment. So I think the trap has to do with, if you get a witness to agree with you, you know, that's good, you use it later on, but if you can go further and get him to commit to something, then the trap is now laid. And I think that's morphs into what was just played now also, that now he's laid the trap, they know what it is. Once the witness makes that commitment to you, he can't go back, and you can use it whenever you want.
Yeah, so I agree with that. The reason I wanted to highlight that clip separately is I have come to believe that a lot of the moments in the courtroom that we think are so magic, the jury doesn't appreciate.
So true.
So how do we get them to say, like, in other words, I think, yeah, we have time. I'm going to play when he springs the trap. That's about a 3-minute clip, which is a little long, but I'm going to play that. But I'm just going to tell you the ending. You already remember. One of the jurors, he says, from the jury box, clear across the courtroom, I can hear one of the men on the jury say, "For Christ's sake." That juror knew something had just happened. Well, it's your job to make sure the jury knows that you made a good point. And so there is a moment, I don't know if maybe it's a different jurisdiction, so maybe they do that up there. I would feel very odd saying that to the judge. But you have to do something to tell the jury something important just happened. Remember that. So any other ideas about how to do that? I mean, I've given you 2 actually, because one is to turn to the jury. What else, guys?
I come back to visuals. Things have changed in the last 25 years since this book was written, and the juries have changed. 25 years ago, you could watch a movie or television, they would edit clips like once every 15 or 20 seconds. Now it's like every 5 seconds. So it's a multimedia driven populace that expect that. They want a show, they want CSI. So for something like this, if you're not using an Elmo to write it down, if you're not using a PowerPoint, if you're not using video clips to show it, something as simple as the flip chart, making an agree board, pausing to write it down. Lanier has been a huge I think a lawyer who's advanced this more than anyone else, using metaphor, using drawing. There's a great book by Dan Rome called, well, Dan's actually got a series, but talking about just drawing stick figures. It is tactile. It's something you can do to connect with the jury visually. So today, my biggest criticism of this, and I was going to save this after the trap, is that he didn't use any visuals. They expect that. It could be a timeline with a designed metaphor that you would draw. Like Lanier's got one, it's the jukebox, and he's, the witnesses' faces in the jukebox, and, the defendant's feeding the coins in the jukebox, and he's writing the names of the songs that the witness is being paid to sing. It's a metaphor, but it's powerful and it's visual. So my only criticism is of this trap, I think it could have been dressed up in metaphor, dressed up in visuals, and actively had Sandy use those tools. I think it would have hammered this thing, and then he can bring it up with other witnesses and bring it up in closing too. So
the Scott's idea, because I use it also in the board, right? Still to this day, writing on the board. When you have that opinion up there about the spermicide, you write right across it in red, absurd. And that jury will never forget that he said that his own opinion, which is about to come out, was absurd. Because it's written right there in front of them and they're going to write it down in their notes. Additionally, we have real-time reporting now. And so you don't have to ask the court reporter to put a paperclip on the papers anymore. You just have a real time, so the judge is seeing it, the defense lawyers are seeing it, you're seeing it right in front of you. And you can just have it on an iPad, which I do. And you could just, if he questions any of it, you just scroll down on the iPad and there it is. But visuals are, as Rich said, vital in today's world.
Yeah, so you can make your presentation far, far more convincing with visuals. I'm not that good at visuals, and that's a weakness. Did you know that I just found this out? Like, if you close your eyes and someone says, like, picture a beach, I just found out that you guys can picture a beach. Like, when I close my eyes, all I see is black. Like, I can't see. There's no, apparently it's like 1/2% of people have that. So I'm not very visual and I have to rely on other people. But at least you know my weaknesses. But I'm not disagreeing with you one bit. You guys are 100% right. And I agree with you. The visuals are powerful. It's how we learn. It's how we remember, how we convince. Still, we can learn because you can paint pictures with words. You can make points with words. So while he should have done everything you say, like, I agree, he could have made it easier on himself. He still, there's an art to what he's doing that we should do also if we can learn it. It's hard. That story I told about Bob, not to go back to it, but not saying, I know you just said you're not being paid to lie, but if you put those words into every question for 20 minutes, well, how does that fit with you not being paid to lie? You have many tools, so let's try to maximize all of them. So Sandy Stern can teach us some things and not others. So he's not going to help us with those things, Rich.
The one thing that occurred to me, John, about that bit where he asked the court reporter to mark those last 5 questions in order to emphasize to the jury how important it was, it reminded me of that great cross-examination in A Few Good Men with Tom Cruise asking Jack Nicholson about it, and he gets Jack Nicholson to kind of give him a different answer, and he goes, wait a minute, you just told me this, and I said this, and you said this, and I said that, and you said this, and I could ask the court reporter to read it back. And that was just I thought that was a great technique for emphasizing something in the testimony in a cross-examination.
Yeah, so that's brilliant. Didn't, who wrote A Few Good Men? Wasn't it the first thing that Aaron Sorkin wrote? So it's like, it's a genius who wrote it, so we remember it. But so if we were Aaron Sorkin could do a cross, but I'm sure. But we should try to do a cross like in A Few Good Men, so that when Tom Cruise has to say, remember, I said this and you said this, we all remember it. We should try to talk like that. But I want to disagree a little bit with you, Scott. because you're saying emphasize the point. I'm sure you guys are sick of me talking about being a juror. And I talk in almost every talk about that paint it pink study. It's not emphasizing. It's just hoping they hear it, even once. The most of what we do in the courtroom is just plain missed. It's boring. There's no. With Aaron Sorkin, he has Tom Cruise raise his voice, goes in for a close-up. There's a million ways he tells us this is the thing to remember. And then 3 minutes later, we remember it. We don't do that in the courtroom. So when I'm sitting there as a jury, it's like, brrr. And by the way, we don't even have any context. So this point that I would know is important at the end of the trial, they're telling me it at the beginning. We think it's emphasis because we think the jury knows what we know when they don't, and we think we're so great at communicating when we're not. So I would suggest to you that the jury might not have even heard that trap if Sandy had sprung it when I would have, normally, and if he hadn't done any of the dramatic elements of it. I have learned some of those, so maybe they would have remembered mine, but maybe not. And if in my next cross-examination, what I'm going to take from this cross is I'm going to go further and they're going to remember it, right? Because also now I've been a juror. I am going to tell the jury in 15 ways, this is something you need to remember. This is important. I don't want this to turn into just a bunch of stories, but I'll tell you another story about Shelley. Because, and you know, keep this between us. There's so many people, but listen, there was I tried his last case with him. Okay. And so he wasn't at, you know, we all have our peak of our career, sometimes before, sometimes after. Well, in that moment, when people thought he's so old, he suddenly got up there and he had us all on the edge of our seats, okay, with the drama of the moment, just the intensity, the yelling, at his own witness. But it wasn't in service in that particular moment to anything in the case, right? So I sat there for a minute and I thought, if I had to choose whether I could be dramatic enough so the jury would remember, or I could be logical like me, so I was making an important point, I'd rather be him. That's the power that we all need to work on, that we need to stay. We have to make sure the jury remembers the important point when we make it. So I'm sorry that took so long, but it's not this is like if I could leave you guys with one thing, it's that you're fooling yourself if you think you're emphasizing the point. You're just making it. Hopefully, maybe. So, all right. You guys want to hear how it plays out? Or everyone already knows?
No, I want to hear.
All right, so let's go. Clip 10, please.
Do you recognize the notes of your autopsy of Ms. Polhemus, Dr. Kumagai? Painless flips a few pages. My signature, he says. Would you please read aloud the short passage marked by the paperclip? Sandy turns to Nico. Page 2, counsel. Kumagai has to change glasses. The fallopian tubes are ligated and separated. The fimbriated ends appear normal. Kumagai looks down at the sheet he has read from. He pages again to the end. He is frowning, deeply now. Finally, he shakes his head. Not right, he says. Your own autopsy notes? You dictate them as you are conducting the procedure, do you not? Surely, doctor, you are not suggesting you made a contemporaneous error. Not the right, he says again. Stern comes back to the defense table for another piece of paper. I have gotten it now. I look up to him as he takes the next document from Kemp. I whisper, are you telling me that Carolyn Polhemus had her tubes tied? It is Kemp who nods. The next few seconds are blank. Weirdly, unaccountably, I feel alone, locked in my own teetering sensations. An essential connection has been interrupted. For a moment, it is like déjà vu. I cannot make out reasons. What takes place in the courtroom seems remote. I'm aware in a dislocated way that painless Kumagai is being devastated. He denies 2 or 3 more times that it is possible that Ms. Polimas had had her fallopian tubes surgically separated to prevent conception. Stern asks if other facts might affect his opinion and pushes into Kumagai's hands the records of the West End gynecologist who performed the tubal ligation 6.5 years ago after Carolyn aborted a pregnancy. It was this doctor, no doubt, whom Kemp went to meet yesterday afternoon. I ask you again, sir, would those records alter your expert opinion? Kumagai does not answer. Sir, is it now your expert opinion that Carolyn Polhemus knew she could not conceive? Apparently. Kumagai looks up from the papers.
It's absurd.
In my confusion, I find that I actually feel sorry for him. He is slow now, hollow. It is to Molto and Nico he speaks, not Stern or the jury. I forgot, he tells them. Sir, is it not absurd to believe that Carolyn Polhemus used a spermicide on the night of April 1st? Kumagai does not answer. Is it not unreasonable to believe that? Kumagai does not respond. Is it not likely that the specimen containing the spermicide, the specimen identified as containing fluids of Mr. Savage's blood type, was not taken from the body of Carolyn Polhemus? Painless shakes his head again. But this is not denial. He does not know what occurred. Sir, is it not likely? It is possible, he finally says. From the jury box, clear across the courtroom, I can hear one of the men say, "For Christ's sake."
So I felt it when I read it. I still feel it right now. But all they did was eliminate the fact that the perpetrator had the same blood type as the defendant. That is the only piece of evidence that was destroyed in that cross-examination. All the other evidence that they have stands. And yet it feels like the whole case has collapsed. So that's the power of destroying a witness. So I'm going to say one last thing and then get comments from everybody about anything you want on this. I believe that cases are won and lost on cross-examination. People who tell you that it's in other aspects of the jury trial, you should nod politely and not listen to them. Here's why. The jury, especially with expert witnesses, the jury expects your expert to slant things toward you. And they expect the other side's experts to slant things towards them. They're not that unsophisticated. There's only one thing they can take to the bank. That is an admission that hurts you by your own expert, an admission that hurts the defense by their own expert. That's where the cases are won or lost, in my opinion. So what he did here was win his case. Even though he didn't really win the case, he won it in a much more powerful way than me with my narrow, non-visual, logical mind would want to think. And so this helps me. So guys, what do you say about anything? And anyone who wants to raise their hand, we can bring you on.
I agree that he didn't prove conclusively that the person was not the rapist and murderer, but he created certainly a reasonable doubt that the prosecution was honest. And and that's all he needed to do. And he did that in this case by destroying their main witness. And only thing I would have added, and maybe would be piggish of me at the end when he was a broken witness, doctor, let's agree. She was not fertile because she had her tubes tied, and therefore your opinion was absurd. And whatever he says, and walk
Right.
away from it. Because that word absurd, you can use it again and again in closing, you use it with other witnesses, whatever it is. Your opinions in this case, as it comes down to it, as the facts now show, are in fact absurd. I don't care what he says.
It's right. That's a great example of a question that it doesn't matter what he says, and maybe that you should look at the jury when you say it.
Right.
But let me add one other point to that, Gary, because you said something much better than I said it. But I think we agree. You said it in a way that we're disagreeing. What you said that he didn't just eliminate one piece of evidence, he destroyed the credibility of the prosecution. He did that by destroying the credibility of the witness. And so that's why I say, if you destroy the credibility of the defense's expert, like we won that trial because their expert, Lee Carr, was destroyed, and so their whole team was destroyed. You can win your case on cross. You can destroy their case just by destroying the credibility of the witness. So I think we agree.
Yeah, and to that point, you know, Jim Gilbert, John, you know Jim, he's a great lawyer out of Colorado, founder of the AIG. He always said that I'll trade my two good fact witnesses for your liar any day of the week.
Right.
And to that point, man, as soon as one side gets hammered in terms of their credibility, it's over. The other oh, great, my dog's barking. The other point that I would make is that I think he let the guy off the hook at the end, showing that it's not just a lie or a mistake, but it's malicious. And this whole thing about the guy wanting the appointment and he needed the favor of the prosecutor, I would have hammered that. I would have made that into its own metaphor and required him to answer specific questions about that whole process, how much he'd make. I was just thinking about how I would do that differently, but it's not just the lie, it's the motive for the lie that I think could have really gone a little further and gotten that case.
Yeah. All right. So Herb, quickly, I want to try to wrap it up. I try to keep them to 1 hour and 15, and we're already at past 1 hour and a half, but go ahead.
I want to say, here's what I get out of coming here and doing this. You guys all have such great experience. We've done this. For me to go to one of you or vice versa and say, hey, what do we do in this case? Oh, destroy the witness. Okay, great, thanks. Of course. But here's what I love about what you did, John. You take this stuff and you identify who you are and what you are and how you process things in the courtroom. Because I'm thinking, until you admitted it, that you don't have this visual. You don't have the creativity aspect of it where many other lawyers do, where Shelley would make faces. But then you realize that and apply and think about how you would do it differently. And that, to me, is a compliment for all of you, the beauty of coming here and sitting and listening to you guys and walking away with expanding, not our experiences, but where we can go from here. I love how you process this, John. Thank you.
Well, I appreciate that. And in a way it is, we're sharing our experiences so we all learn from each other. So thank you guys, all the volunteers with the alcohol, making the drinks, and all the panelists and everyone who spoke. I really appreciate you coming on. And if email me, if any of you guys want to try this, I want to try one of the curious elixirs that has no alcohol. Maybe it'll make me a better one. All right, guys.
Herb,
thank
good
you.
seeing you, Herb.
Nice seeing you, Gary.
Right, Rich.
Take care,
bye-bye.
guys. It was a pleasure. John, thanks so much. It was fun.
Absolutely.
Yes, it was. Thank you.
John. Thanks, Rich. Good seeing you.